Was the TSP or any other surveillance program outside the scope of FISA in place prior to the authorization for the use of military force?
No.
Okay.
It began in October.
It was
October of 2001.
And when was the legal opinion for this authority issued?
The President was advised that it was lawful before the program began.
After the authorization, at what point after the expiration of the 15 days did the President revert his authority under FISA?
I'm not sure I understand the question. The 15 days,
15 days
does not apply. It applies only when there's a declaration of war. Section 111 of FISA
So you're not claiming the
applicable.
15-day,
That's correct. I would say, and I'll try to be brief, that 15-day provision in Section 111 of FISA, in our view, does not say you only get.
It says you don't have to get a warrant for 15 days.
But it does not purport to mean that Congress made a judgment that you only need 15 days of authority during time of war to conduct surveillance.
No, it means the expectation when that was passed was that you have 15 days to go to Congress if you thought you needed more authority to act without warrants.
And in our view, the authorization for the use of military force was an act of Congress that did
Which
give
gives
that
the President limitless authority.
not limitless.
But authority to act without warrants.
All necessary and appropriate authority to repel the threat and to prevent.
And that means that as
attack.
long as we're fighting the war on terror, the President can have surveillance of Americans he believes to be in communication with Al-Qaeda in the United States without getting warrants from the FISA court.
It does not mean that. Anything the President does, the authorization is still in effect and does still give authority to the President, but anything the President does has to be consistent with the Constitution, has to be consistent.
But under your interpretation of the Constitution, his inherent Article 2 powers, he can wiretap people without a warrant from the FISA court.
It all depends on the circumstances at a given time, and the Fourth Amendment has very real application here. Any surveillance has to be reasonable under the Fourth Amendment. That takes into account all the conditions and circumstances at the time and the nature of the surveillance that you're talking about. So that is, if, for example, Mr. Chairman, if the President wanted to reauthorize the terrorist surveillance program today, my view is it would require a new legal analysis, a new judgment based on all the current circumstances.
Okay. And he's done that 45 times?
I don't know about the exact number. It was every 45 days, approximately.
Every 45 days he's done it. When was the first discussion after 9/11 with members of the department about undertaking electronic surveillance outside FISA? And
well, again, our view is that the surveillance of this program is consistent with FISA, Mr. Chairman.
No, your view is that, I think that what you've said is that your view is that under the President's inherent power and under AUMF, it supersedes FISA. And that is consistent with FISA.
I think there have been some rather extravagant claims about what our argument is. Our argument is primarily that you need to read the authorization for the use of force consistent with FISA to harmonize them. There's a provision in FISA that says...
Wait a minute. It doesn't make any sense. The FISA says you can wiretap people in the United States with a warrant. I've always understood you to say that under the AUMF and under the President's inherent power, you don't need to obey that provision of FISA, correct?
I'm sorry, FISA doesn't say with a warrant. FISA orders are not necessarily warrants.
Excuse me. You need a FISA order. Never mind the nomenclature. You need a FISA order under the Your claim is that under the AUMF and under inherent power of the President, you don't need a FISA order.
FISA says except as otherwise authorized by statute. The AUMF is a statute.
Correct. And AUMF being a statute, your interpretation is that AUMF supersedes FISA.
No.
Therefore,
doesn't supersede FISA. FISA says as except as otherwise authorized by statute. So it's consistent
all right.
with FISA.
We're playing word games.
I think it's very fundamental.
We're playing word games. Your claim is that under the AUMF authorizes the surveillance without a FISA order, and that's consistent with FISA.
Correct.
Okay. I would say that means it supersedes FISA. It doesn't matter. Is an October 2001 OLC opinion regarding presidential power referred to in the August 2002 so-called torture memo? Was that October 2001 opinion part of the consideration by the Department of the legality of electronic surveillance?
I'm not sure of the exact opinion that you're referring to. I would say there are opinions from the office regarding this.
Well, the Congress has repeatedly asked for copies of the OLC opinion. Will you furnish copies of those opinions to the committee?
No, Mr. Chairman.
Why not?
Because those reflect the internal confidential legal advice of the executive branch. Those are
What
deliberative.
privilege are you asserting?
I'm not asserting a privilege.
Then
I'm
have
telling
you not give it to the committee upon request?
Because-
Either you assert a privilege or you give it to us. One or the other.
No, Mr. Chairman, we respond to all requests from the committee. If the committee makes a request for the document,
We have made such requests.
and I believe we've responded and
By saying
explained
you won't give it to us.
that the confidentiality interests of the department, but we've done something that is rather extraordinary, and that is we prepared in January of 2006 a very extensive white paper for the purpose of explaining to the Congress and to
That's very nice, but it doesn't give us what we requested, which is those legal opinions.
It does.
So unless you are asserting a privilege, there's no alternative. What privilege are you asserting?
We are citing the confidentiality interests that the executive branch has in internal, confidential, deliberative advice of the executive
So that's executive privilege you're asserting.
I don't assert executive privilege, Mr. Chairman. The President asserts executive privilege.
Well, you just stated that the President exerts executive privilege.
I stated that there are important confidentiality interests with respect to internal advice. And
Isn't that the definition of executive privilege?
No, it isn't. Those are the types of interests that would support, if necessary, an assertion of executive privilege by the President. That is something we like to try to avoid.
Oh, so you're
But we have
saying
not
you won't
done
give,
that here.
So you're saying you won't give to Congress to request the documents because they deserve executive privilege, which you haven't yet asserted.
They do partake of the confidentiality interest of the executive branch. That is an interest that could support an assertion.
All right, let me stop playing this game. Has any part of the October 2001 OLC opinion been withdrawn, modified, or clarified in any way since then? And if so, what are the changes?
I'm not going to discuss the internal legal deliberations of the
Did
Department
the Department of Justice Office of Legal Counsel issue an opinion or more than one opinion concerning electronic surveillance?
The Department of Justice Office of Legal Counsel has reviewed the legality of the program and has reviewed it more than once.
And are any part of such opinions currently classified?
All such opinions are currently classified.
Okay, I see my time has expired. Thank you, the gentleman from...
Thank you.